All right, we're back live, and thank you, Council, for your patience. Good morning again. I'm Judge Jensen, Powell, the Kansas Court of Appeals, and welcome to the Wednesday, May 12, 2021 docket of the Kansas Court of Appeals. We have three cases on the docket this morning. With me on the panel is Judge Thomas Malone and Judge Catherine Gardner. We will take up the second case on our docket this morning. State of Kansas versus Dalen Vessar, case number 122769. Could the court have the appearances, please?
Good morning. I'm Jonathan Lawrence for Appellant Dalen Vessar.
May it please the court, the appellee, State of Kansas, appears by Stephen Obermeyer, an Assistant Solicitor General.
Very good. Thank you very much. Mr. Lawrence, I know that you're the appellant in this case. How many minutes would you like for rebuttal?
May I please split my time 10 and 5?
You bet.
Thank you, Your Honor.
10 minutes.
May it please the court. I believe that there are two primary issues for discussion this morning. The first being at the inception, the procedural question of whether the state should have been allowed to proceed on a superseding indictment. I suggest that this is statutory in nature. On February, I believe it was February 21st of this year, another panel of this court in a case, State versus Byrd, I can provide if I need to through a Rule 609 letter, but it's number 120816. I believe Judge Malone was on the panel. Did not directly address amendments to indictments, but did note that it is statutory and should be taken literally. I believe it is actually in the fourth head note in the syllabi. The state's ability to amend charges in a grand jury indictment is limited by statute. Substantive amendments are prohibited except for the limited purpose of effecting a change of plea by the defendant pursuant to a plea agreement. If we start with 22-3001 and go all the way up to 22-3015, you will see no statutory authority permitting superseding indictments. The state's argued that these were two separate cases combined. Not at all. You can go look at the original indictment. There's only been one case number here in Shawnee County. And you can look at the original indictment after the mistrial where the jury was hung on the sole count of the January 2016 registration. The state went and got a superseding indictment without consulting the court. That's not statutorily allowed. And I believe that the statute's control here. I also believe that the state's reliance on 3201 is misplaced because we're not dealing with a complaint or an information. The procedural issue would end the case because if the counts that were added after the first trial are prohibited, what we're left with is the original count, and Mr. Vessar was acquitted in the second trial of the original count. Turning to the substantive issue, I think it's pretty clear based on some cases that have come down, say in the last 9 months, and I don't need to cite them, I'm sure the court's aware. Cora has been repeatedly held to be constitutional in terms of its strict liability nature.
Mr. Lawrence?
Yes.
Let me interrupt you to back up to your first issue. Are you saying that all superseding indictments are invalid because there's no statutory authority for them?
I'm saying, well, two things. The first thing is the procedure would involve going to the judge and getting permission and allowing the defendant to be heard. That's what 3015 says. That's the procedure of 3015. So there is a procedure to allow the amendment. It just has to involve the defendant and it has to involve the court. That's the way the legislature has spoken. In terms of the cases before this, The only case that actually talks about 3015 is Byrd, but it's in dicta, and it wasn't, Byrd, by contrast, in this case, Byrd was the dismissal of an indictment that was allowed. And this isn't a dismissal of the indictment or the superseding indictment. This is the opposite. This is the supplementation of the original indictment with new charges without first seeking court intervention. I noticed on Westlaw, there are 22 cases that mention the phrase or the words superseding and indictment in the same sentence. None of them deal with superseding an indictment. To the extent that there's mention of superseding indictments in other Kansas cases, the overwhelming majority refer to parallel or prior federal proceedings. In other words, it's just in the fact pattern. But to the extent that there was one case, the name escapes me, where in the procedural history of the case, superseding indictment was discussed, there was no objection. Here, there was a timely objection. There was a motion to dismiss litigated. Judge Everts decided to allow the case to proceed. I feel it's properly preserved. And so I don't think that all superseding indictments are nullified. I just believe that in this case, it was caught by trial counsel, and the state was called out on the fact that it didn't follow the proper procedure and didn't involve the court. The court, the district court had the, had the power, if consulted properly, and with notice to the defendant and an opportunity to be heard, the district court could have allowed it under those circumstances. But this is a classic case of asking for forgiveness rather than permission. And so statutorily, my client's invoked his right to the due process of 3015B.
Thank you.
With respect to the second issue, what I believe is, I think two things can be true at once. So I believe that we can preserve the case law that says that core violations are strict liability, while at the same time also acknowledging the Court of Appeals and the Supreme Court's recent rulings in State versus Harris, which I supplied in a Rule 609 letter last summer. Now, the Supreme Court stopped short of dealing with the mistake of law defense that the Court of Appeals approved of. And so to the extent that the Court of Appeals decision was overruled in the Supreme Court version of Harris, it wasn't overruled on the mistake of law defense. It was overruled on the vagueness in the statute prohibiting possession of a knife or defining a knife, right? So in Harris, we had a parolee who went and sought guidance from his parole officer and was told he could possess a certain type of knife. When he was later found to be in violation of parole for possessing that knife, he wanted to raise the mistake of law defense. I believe that case controls here, but just with a couple of distinctions. In Harris, the defendant's offer of proof about the parole handbook and about what his parole officer told him were suppressed in a motion in limine by the state. So the state sought to keep the evidence out and the trial court agreed. That's what went up to the Court of Appeals. The Court of Appeals said the trial court erred and that the evidence certainly should have been admitted, but then found harmless error, okay, based on sufficiency of evidence and other matters. The Supreme Court only dealt with the constitutionality of the definitions of the knife, but there was discussion in both cases about the authority of the parole officer to interpret a statute and give advice. In this case, we have an officer empowered to direct and control supervisees who are registering under CORA. And although it was a begrudging admission in the second trial, both deputies Ashley Previty and Dustin Carlat, I'm probably mispronouncing the name, I apologize, but they both did begrudgingly admit that they had been affording supervisees grace periods. The difference, and the state conflates these two in its statement of fact, but what's really important here, the first trial, Previty was very clear. She allowed a 15-day grace period. In the second trial, the state's witnesses refused to disclose to the second jury how long the grace period was. Now, Mr. Vessar's counsel, in 2 or 3 places throughout the record, references 15 days, and both witnesses in the second trial, which is the only trial that matters when we're talking about sufficiency of evidence and things of that matter, both witnesses did indicate that there was grace period, but they wouldn't tie down the time frame. The point being, the unfairness in this case is that the evidence was allowed, but then the jury instruction wasn't. So Mr. Vessar got to present his defense about being misled by Deputy Previty, but then the jury was told, no, it doesn't, you can't consider that. You can only consider the statutory elements. So,
Mr. Lawrence?
Yes.
Let me ask you whether there's evidence in the record that the defendant was ever told that he didn't need to strictly comply with the Cora deadline.
I can't quote or cite to the page, but he testified about it. And so that is evidence. And of course, both deputies did acknowledge that there was a grace period and that he came in May for the April registration period. Remember, there was an allegation that he didn't register in January at all. He was acquitted of that. So whether the jury believed him or did not believe there was enough evidence of his failed registration, he was acquitted. Then we have the April and July. April's registration, he registered late in May. The July registration, the kid, we're talking about a 20-year-old kid, got confused. He registered in Wyandotte County instead of Shawnee County. There was no dispute over it. He moved. So what he technically failed to do was, quote, register out rather than register in of Wyandotte. But against that factual backdrop, I hope that answers your question. He did testify what he was told. So
thank you.
I noticed that I'm right at the almost 11-minute mark. So if there are no further questions, I'd like to reserve for my rebuttal.
Very good. Thank you very much. Mr. Obermeyer.
Thank you. May it please the court, the state appears by Stephen Obermeyer. With regard to the first issue concerning the superseding indictment, as Mr. Lawrence indicated, there was not a lot of case law on the issue. The trial judge mentioned that in his ruling and ended up defining what a superseding indictment was, and that the superseding indictment with the additional 2 counts controlled over just amending the initial count 1 on which the defendant was later acquitted. The Byrd case dealt with a state dismissing 1 of 2 counts in an indictment in order to appeal the district court's dismissal of another count on the second day of trial or before the jury was sworn. And the issue was whether or not a dismissal of a count was an amendment under the statute KSA 223015. In the brief, the state's brief, there's about 6 arguments as to why this was not reversible error, at least. And I likened it to consolidating cases together. If a grand jury had indicted on counts 2 and 3, which are also Cora violations, that could have been consolidated with what count 1 was. The purpose of the statute was affected in that the defendant was allowed continuances to prepare for trial, to apply for diversion. There was judicial review by the trial court as to the propriety of the amendment, and the trial court did not dismiss the case at that point, and ruled that the statute 223015 did not apply given the superseding indictment. I argued that the purpose of the Code of Procedure is for just determination in every proceeding, and so adding these 2 counts as you would like a consolidation did not impinge on the defendant's rights. And I cited KSA 60-2105, it didn't prejudicially affect his substantial rights. And in addition, the remedy for a violation of this statute is the statute does not say if you violate 22, 30, 15, the case shall be dismissed. The legislature knows how to use that language. In fact, the legislature has that language in the speedy trial statute, KSA 22-3402A and B. If you're not tried within 150 or 180 days, depending on whether you're in custody or out on bond, he or she shall be entitled to be discharged from further liability. We don't have that language in 22-30-15, and it is more like the statute that says you are entitled to a preliminary hearing within 10 days, the McLean case. And the remedy in McLean was not dismissal of the case because there was not a preliminary hearing within 10 days. Unless the court has any questions on that, I'll proceed to the second issue. And what I'm hearing is it sounds like whether a mistake of law defense should have been given. I'll just lead with my harmless error argument that Mr. Vessar was well aware that he had to register in the months that January and April for sure. It seemed that after his probation terminated, his complying with registration became more difficult. And he was not surprised about the months in which he had to register. He signed the initial about 15 different paragraphs setting out all the requirements that he had to do as far as reporting. The fact that on a previous occasion he thought he had a 15-day grace period. Even if as the state argued in closing, even if the jury considered that he did not register within 15 days, the first 15 days of May. He was in Colorado on a trip with his girlfriend for about 3 weeks and had previously testified that he thought he was back before the 15th of May. It turned out he didn't get arrested or get a ticket in Geary County until I think the 16th of May, bonds out on the 17th, and doesn't bother to register for April until May 22nd. So even under the mistake of fact argument, there's not error on that. And the Harris case, as mentioned in the 609 letter, mainly deals with whether or not a cutting device language is constitutional. And there is language in there about a difference between what the probation officer said, that the knife that Harris had was not a violation versus the state charging Harris with possessing that knife. This case is different. But as to the primary argument, the statute is clearly a strict liability offense. The legislature has said as much. We have this discussed in State versus Stoll in my 609 letter that talks about substantial compliance is not a defense to a charge for failure to register under the Kansas Offender Registration Act because relaxing registration requirements would not accomplish the purpose of the law. And that's from the Kansas Supreme Court back in February. So, and I think Stoll was just a few days late in registering before Stoll got charged with an offense in that case. I argued that the deputy could not forgive the defendant for filing late. They do not have probable cause arrest for late registration. They just send the information I think to the prosecutor's office, and then the grand jury considers whether they file it. The trial judge in this case wrote a lengthy memorandum, which is in the appendix in the state's brief, explaining why this statute is constitutional, distinguishing the Rehafe case that the defendant had cited and was presented to, that argument was presented to the court. That case involved a statute that said knowingly, and this case is clearly different. The other case cited in the state 609 letter was State versus Jensen, and there are a lot more arguments in the Jensen case concerning constitutionality of the statute. In this case, the argument presented to the trial judge was basically the Rehafe argument, and the trial court distinguished that and denied the motion for acquittal and found the statute to be constitutional. So I think based on the argument presented, as far as constitutionality, that the court could say the statute is constitutional. If the court disagrees, then the error would be harmless as far as the filing was beyond the grace period that even the defendant thought he had. And so the defendant received a fair trial in this case. Unless the court has any questions, I would just argue that the jury instructions were appropriate, sufficient evidence supports his convictions, that knowledge is not an element of a core violation, and would ask that his convictions be affirmed.
Thank you, counsel. Seeing no questions for the panel, we'll proceed to Mr. Lauren's rebuttal, and you have 5 minutes.
Thank you. Taking them in reverse order, again, the 15-day limit or the 15-day grace period was discussed in the first trial. Carlat and Previty, actually Previty in the first trial, set the limit at 15 days. In the second trial, she refused to give how long the limit was. So I'm not trying to split a hair here where I risk my credibility. I realize in the first trial it was set at 15 days, but for purposes of what the second jury heard, not what we know, but what the second jury heard, they were told that there was grace periods, but the witnesses would not define how long. So the fact that he was arrested coming back from Colorado, which is not in dispute, the fact that he registered on the 22nd does not by default create some type of an estoppel for him that he was beyond May 15 when that second jury wasn't told what the grace period was. The Harris case, it's interesting in terms of judicial gymnastics. I believe that part of the Court of Appeals decision in the Harris case is still good law, right? Because the Supreme Court goes out of its way to talk about that it's only dispensing with the review on the constitutionality of the definition of a knife. Justice Biles, in his dissent, goes on at great length to further expound upon the mistake of law defense, does not overrule it, even in the dissent. And I believe he had 2 other justices joining him. I think I'm not really a big fan of metaphors and analogies when we're talking about statutory interpretation, what have you, but just one thing to keep in mind. Deputy Previty was the person supervising this kid. And he really was a kid. I think he was like 19 or 20 at the time. And that's the authority figure who's telling him what he has to do. In the landlord-tenant arena, when your rent is due on the 1st, but there's not a late fee imposed until the 15th or 20th, if a landlord were to come in to any court in Kansas on the 5th and claim that claim a right to eviction, we probably wouldn't allow that. We'd say, wait, your tenant's still in the grace period, right? So the grace period matters. That's what Harris is saying. It's saying when these people are under supervision, under state authority, are told by their officers that they have certain parameters, they're allowed to rely. That doesn't have anything to do with strict liability constitutionality. Now, Mr. Obermeyer did raise something interesting in his brief that that really didn't get touched upon, and that is, I asked for an instruction, or trial counsel asked for an instruction on intent, right? I believe that Mr. Obermeyer correctly pointed out that there's an even more precise jury instruction on reliance on a public official. The reason I did not argue that in the brief, it wasn't specifically preserved below, and it wasn't argued that way below, but that's not irreconcilable with the instruction that Mr. Vessar's attorney wanted, which was the general intent instruction. I think they both coexist, right? If you're relying on a public official, you don't have the intent. So, but the point being, I believe that if this case is not dispensed with on the improper amendment to the indictment, then it should be remanded for a new trial. And Brevity and Carlack can come in and they can talk about whether or not May 22nd was outside the grace period and whether the grace period was 15 days or whether it was ambiguous. But I believe this kid had a right to rely on what he was told. He wasn't arrested May 22nd. He was allowed to register. He wasn't arrested in July when he mistakenly registered in Wyandotte County. What we're talking about is not whether he substantially complied, whether he complied according to what he was told by an officer of the state. So for those reasons, I'd ask that the court reverse, and I greatly appreciate if I've gone over your indulgence in the time.
Well, you're still within your time. So counsel, thank you very much. We appreciate your excellent arguments, and we'll take this case under advisement, issue a written opinion as soon as we're able. Thank you again, and we'll shut down here.